Employers now are required to provide a copy of the employment agreement to the foreign worker after it's signed by both the employee and the employer, which includes details of the occupation and the wages and the working conditions. If you're bringing in an employee under the IMP program, you must do this via the employer portal. Otherwise, it's my suggestion and best practice to just ensure once this has been signed by both parties, you return it by email, or if you're communicating simply by mail, a fully signed copy to the employee, and keep a good record of having this done. And likely best practice is to acknowledge receipt from the employee. Along with the employer contract, it's important for employers, it's a requirement now for employers, to provide their temporary foreign workers with information about their rights in Canada on or before, better practice, before their first day of work. Moving on to employer compliance inspections. As mentioned earlier in my discussion, there is an entire schedule at the end of the regulations, the Immigration Act regulations, that lists the types of non-compliance that employers can be found to have committed. It includes schedules that talk about the number of points that are associated with each of those pieces of non-compliance. Then it talks about the potential range of fines that can be levied against employers who do not comply. Ultimately, with the potential consequence of being permanently banned from participating in the program. Triggers for non-compliance, triggers for an inspection, are known past non-compliance. You can be randomly selected, and there can also be a reason to suspect non-compliance. Reasons to suspect for non-compliance include, the receipt of information relating to an employer using the IMP program or the temporary foreign worker program that would give an officer reason to suspect any non-compliance. This information can come from a variety of sources, including an allegation or a complaint, diplomatic channels or parliamentarians, a non-governmental organization, the media, voluntary disclosure, etc. This is a pathway to permanent residence for skilled workers. There are 3 federal economic programs workers must qualify for, being the Federal Skilled Worker Program, the Federal Skilled Trades Program, as well as the Canadian Experience class. As we're going to discuss later on, there are options for provinces to create programs, provinces and territories, so they can recruit directly from the express entry pool. The goal is that potential skilled foreign workers can access the express entry pool for a permanent pathway, a permanent residence pathway, and this may also be a faster way to access the system.